In the short term, it has rather led to uncertainty because there's a question. There are all those questions that we have discussed. A lot of it continues to apply. A lot will be still familiar, but otherwise, I didn't see much enthusiasm on the side of Parliament so far to be very interventionist in the field of VAT.
My impression is that the Court of Justice of the European Union formulates its judgments in a way that sometimes you don't exactly know why the conclusion is as it is. It seems that Brexit, in that very strict, let's say, sense that we are talking about, may turn out to be something positive for VAT system in the UK.
I might be speaking with the bias of a common lawyer, of course. Of course, I prefer common law judgments.
Welcome to the VATvocate podcast, where we explore all things value-added tax to give you the insights you need as a VAT professional. Hello everyone, I'm Paweł Mikuła and I am independent VAT advisor. And my guest today is Fabian Barth. Do I pronounce it correctly?
You have pronounced it correctly, yes.
Okay. Hi Fabian, how are you?
I'm very well, thank you. Lovely sunny Monday morning and looking forward to speaking about VAT.
Okay, perfect. So Fabian is solicitor in England and Wales, and also in the Republic of Ireland, but not in Scotland, as I understand, right?
That's correct, yes. Scotland has a civil law system. It's quite different than the common law in England and Wales, but Ireland is very similar.
Okay, great. He's advisor in EU VAT law. He's also very well instructed, educated, and specializing in UK VAT law. And also, as I understand, do I understand correctly that you have something in common with the VAT system of the UAE?
Yeah, that's correct. So I have some personal connections to people who are VAT advisors in the UAE. So for the last year, I've been looking into the UAE system as well. It's quite similar to our EU system, gladly. So it's quite easy if you're an EU VAT advisor to get a start in the UAE as well.
Okay, perfect. So Fabian is a person who publishes frequently great pieces on LinkedIn showing different case law, different judgments, description of different judgments, commentaries to different judgments of the UK courts on VAT law, and also of the German courts on VAT law, and also Court of Justice of the European Union VAT law. So Fabian is a person who knows all those systems, and we can have direct proof of this on LinkedIn very frequently. So I really do recommend to follow Fabian on LinkedIn if you're interested in very essential and also with graphs description of different EU legal systems. So thank you for those publications, because also I follow it. So it's really great.
My pleasure. It's always good also when reading a case to have the motivation while I'm doing a post about it. It gives you additional motivation to read new cases quickly. But I'm very glad if people find it useful.
As I said, we have an expert on many different VAT legal systems. So this is great, and this is not a common thing. So it's an honor to have you here once more. Thank you for accepting the invitation. Before we move on to the topic, so let's say the relation between VAT UK and EU law and the Brexit thing and all around this, can you tell a little bit more about what are you dealing with right now? What are the topics that you're most interested in right now? Are there any specific topics? Is the Brexit something you're still researching, or maybe you're just researching the case law of those three legal systems that I mentioned, or what are you dealing right now? What can people come to you for expertise on, and so on and so on?
Yeah, I mean, they can always come to me in principle for anything that's controversial and where the answer isn't straightforward. I guess Brexit will be with us still for a while because we're still dealing with cases during the transitional periods and so on. I've recently been following very closely the developments in the case law around private hire vehicles. So the operators where you have an app and where you can call a taxi through your phone. That has created quite some interesting case law in the UK in the field of VAT, but also in other legal fields that then have VAT implications. So that's something I've been very interested in recently.
Okay, so moving on with VAT law, EU VAT law versus United Kingdom and Brexit, and the topic that that is the main topic of our discussion today. So Great Britain left European Union so that as of 1st of January 2021, as I understand, is no longer a member state of the European Union. So we would have this, it's been 5 years now, we would have this intuition that if the United Kingdom is not a member of the European Union, the legal system of the European Union, including VAT law, but the EU law in general, would not apply in United Kingdom as of this date. But this is only intuition. I know that the thing is more complicated, and in particular, the VAT law, the VAT system is very interesting in that regard, because, as we know, VAT law is based on European Union regulations, on EU law. So VAT law in the European Union is very much strongly harmonized. We have, first of all, VAT directive. We have, second of all, implementing regulation 282, but also other regulations that are applied directly. We have EU law, general principles of EU law, and we have also this huge body of case law of the Court of Justice of the European Union. So we have quite a body of law that was applied in the United Kingdom before Brexit. So, and also, if you take, for example, the VAT directive, it is so highly harmonized, it is so detailed that in some instances you could also almost copy paste it and create a national VAT law. So the harmonization here is very, very strong. So this is the general background. And as I understand, before 2021, so 2020, for example, this whole body of law was applied in the United Kingdom, but something happened along the way. And so let's talk about this history of withdrawing from the EU VAT law in the United Kingdom. We assume that our listeners are not experts on this, so let's break it down step by step to see what was those steps. So as I understand, the first milestone on this journey, the first thing that we need to talk about is the 1st of January 2021. This is the first milestone, as I understand. Correct me if I'm wrong. If I'm right, please tell us what happened on this first milestone, or you want to begin with something earlier.
Yeah, I guess it makes probably sense to begin slightly earlier. So during the UK's membership in the European Union, we had actually a domestic enactment, the European Communities Act from 1972, that gave effect to EU law in domestic law. The reason is that in the UK constitutional order, Parliament. There's something called the sovereignty of Parliament. So Parliament is supreme, essentially. It's the highest lawmaking body, and it can't. Well, the fact that the government signed treaties with the European Union wouldn't give as such effect to EU law in the domestic legal order. So we had this enactment, which sort of acted, the Supreme Court called it once the conduit pipe through which EU law came, was given effect in the domestic legal order. So we had already wording in domestic law that gave effect to EU law. At the end of the day, in essence, for the single sentence that just said, well, all rights, obligations, liabilities, and so on, as they arise from EU law, shall be given effect in domestic law and shall be followed and enforced accordingly.
So generally, before 2021, in layman terms, it's the thing that the whole body of the EU law. Let's focus on VAT law, because I understand that there might be some details depending on whether it's a civil law, environmental law, administrative law, criminal law, and so on. But speaking about EU law, before 2021, the whole body of the European Union VAT law was applied in the UK, in the United Kingdom, pretty much as we apply it in every other member states.
Exactly. Yeah. And I would say that the UK courts, on occasion, also in the field of VAT, went quite far in terms of this consistent interpretation, confirming construction under the leasing principle. So they were, when necessary, willing to go quite far in terms of well, not ignoring but interpreting, stretching the domestic law if necessary to give effect to EU law.
Okay, so your impression or your knowledge is that actually the UK courts, indeed, they applied EU law and they were using it in a wide sense, and it was really applied. There was no discussion, no problems around that with regard to VAT. We are talking about VAT.
Yeah. I mean, there were always some cases where difficulties arose, but overall, my impression, contrary to what one sometimes reads or hears, I think the UK courts were, at least in the field of VAT, willing to go quite far to implement EU law.
Okay, that's a very interesting point. Yeah, that you're, because sometimes we hear different political statements or some statements not from the experts how the things are, but when we go to the level of experts, we hear something else. So you're confirming that it was pretty far-reaching for the courts to take everything from what there was to take from the European Union VAT law in the UK before Brexit. Okay,
absolutely. Then came as the first milestone in the withdrawal, if you like, the 31st of January 2020. That was actually the date when the UK formally ceased to be a member of the European Union. But we had this transition period of 11 months from February 2020 until the end of the year, when actually all EU law obligations and rights were still applicable to the UK. So for legal purposes, VAT included, the UK was treated as if it was still a member state. So for all practical purposes, it's fair to say it was the 1st of January 2021.
Okay. So we have this period between February and December 2020.
Yes.
Not formally a member, but from the practical perspective, the whole body of, again, EU VAT law was fully applicable in the United Kingdom.
Absolutely, yes, that's correct. And the courts could also still make references to the CJU, so really everything continued to function as before. And then the 1st of January 2021 was really the key date when, for legal purposes as well, the UK became a third country from the perspective of the EU, and when all EU member states from the perspective of the UK became treated as third countries as well. I'm leaving on the one side for today, I think Northern Ireland, which has some special arrangements. But so when I'm speaking about the UK today, that shall be construed as referring to England, Scotland, and Wales.
Should we then use Great Britain or something? Because it's always confusing. I don't know. But I think the United Kingdom, with the reservation that we are not talking about specificity of Northern Ireland, is quite good expression, right?
Yes. And I mean, it's not like Northern Ireland is also for VAT purposes carved out entirely. It's just in relation to goods, there are certain specific arrangements to avoid having the hard border between the Republic of Ireland and Northern Ireland, so that there are some special arrangements that need to be considered on their own. That probably
maybe we will have the opportunity to come back to it, because our listeners are generally very busy tax practitioners and tax professionals, so maybe it is good to also systematize it. But maybe we will come back to the problem of Northern Ireland later. Now we are moving to the 1st January 21.
Exactly, 1st of January 2021. That's when the UK ceased being a member. It would have left significant gaps in the domestic legal order, I think, if EU law would have disappeared on that day. Not only in the field of VAT, but also in other fields of law where EU law plays a significant role. So what Parliament did was quite clever, actually. They took essentially the wording from the European Communities Act and said, okay, we'll take a snapshot of EU law on the 31st of December 2020, and everything in EU law that existed until this day and that was enforced, available in domestic law in the UK, shall continue to be enforced and shall continue to apply accordingly. In relation to this body of law, the principle of supremacy of EU law shall continue to apply, so that still domestic law would need to be given an EU law conforming construction, for instance, where necessary. And they said, well, judgments of the Court of Justice of the European Union that were released until the 31st of December 2020 shall continue to be binding in domestic law.
Yeah, so we have like this concept of snapshot is very interesting, and I liked it very much. So the EU VAT law, again, we are focusing on this part, on this sphere. So EU VAT law, as it was on the 31st of the last day of December of 2020, it was to be applied strictly as it was on that day. So, for example, if the new law concerning VAT was passed in 2021, everything remained in place except that one change amendment that, for example, was done in 2021. And also, as I understand, if there was any amendment into European Union VAT law, that should be omitted as not a part of the UK system, right? After 1st of January 21, in principle.
Yes. So if we are speaking about the legislation, so the directive and the implementing regulation, that was taken in the form as it was on the 31st of December 2020, and that was what was domesticated, if you want, into UK law. A change in the directive that took effect, for example, in April 2021 or later, would have no impact on UK law whatsoever anymore.
Okay, perfect. And if we want to break down the European Union VAT law into those 4 building blocks, namely directive, implementing regulation, case law, and general principles of EU law, can you walk us through those 4 elements? Were they fully applied in this period after 1st of January 21, or were there any differences?
Yeah, sure, that makes sense. So if we start with the directive, there was actually nothing in the Withdrawal Act that specifically said that directives are preserved. But because you had the principle of supremacy that was retained, and because you had the rights and obligations that followed from the directive retained, nothing really changed. So cases that were litigated after 2021, or even those that concerned transactions that occurred after 2021, were still pretty much discussed by the tribunals and the courts as if the UK had never left. So the directive was still applied. We also had cases where direct effect was enforced. So to give one practical example, the UK had introduced anti-avoidance legislation in the field of insurance intermediaries. So what you quite often had is that an insurer would be based on some offshore UK island. So, for example, in this case, it was in Gibraltar. So the insurer would be based in Gibraltar and would provide insurance to people in the UK, which, from a regulatory perspective, you can do. And then the insurance intermediary in the UK would provide their services to the insurer in Gibraltar, because that's a third country from an EU VAT perspective. The insurance intermediary would recover full input tax, notwithstanding that it's insurance intermediation, because your customer is in a third country. And the UK introduced anti-avoidance legislation that said, well, as long as the insured person ultimately is back in the UK, we are going to deny input tax deduction. Such legislation has no basis in EU law, so the directive is very clear. Financial service to a recipient in a third country, unless you can invoke Halifax, but you couldn't here, you get full input tax recovery. So the tribunal found that Article 168 of the VAT directive had direct effect in that regard, and that the domestic legislation had to be set aside, had to be disapplied for that purpose, so that you could recover input tax. And that was the case, even though the transactions occurred in the period between 2021 and 2023.
Okay, so we have really strong proof in the case law of the United Kingdom that everything applied as it was before Brexit in 20. What was the case, 2021 or no?
Yes.
And the scheme, the taxable transactions were also taking place in 2021, right?
Yeah, it was the decision from the tribunal was released recently, but the transactions were in 2021, 2022.
Okay, so even now yes, even now they accept this, and they recognize this state of law that in 2021, even now they rule that everything was in place as in terms of EU VAT law. In 2021, everything was in place as before Brexit, even when the scheme is, let's say, doubtful from the point of view whether it is kind of avoidance or something, and even though there was a question of the right to deduct input VAT, and even though, as I understand, the direct effect of the directive had to be applied, not only the pro-European Union interpretation, as we call it, at least here in Poland, but direct effect is really applied in terms of the factual background, if you will, in the period 21 onwards.
Yes, if we're pre 2024, I think we'll get to it later.
Yeah.
But that's still the case, and I think it's not very much surprising, because that has been precisely the aim of the Withdrawal Act 2018, to ensure that consistency. It explicitly said, well, any rights, obligations as well, but any rights derived from EU law that were available in domestic law 31st of December 2020 are retained into that period.
Mm-hmm. Okay, it's also interesting for me to hear it because sometimes as we experience it in Poland, but not always. Sometimes in other countries, the law says A, but the courts sometimes apply B. Especially when it comes to some kind of political frictions. Let's say they could find a leeway. I understand that would allow them to somehow avoid applying EU law. But I understand from what you're saying that at least in EU VAT law, the UK tribunals applied EU VAT law even after 1st of January 21.
Yeah, I think in general, the UK courts have. It's fair to say they have not been very political in that regard, whether it's in the field of VAT or other fields. They just genuinely, I think, that can be said about all courts and tribunals in the UK. They genuinely try to find what is the legally correct answer.
Yeah, okay, perfect.
Quite isolated
to
from politics. Yeah, no, it's
hear
very...
this. It's not that obvious in a current world. Not only speaking about Poland, of course, I'm not speaking about Poland at all, but globally, this tendency also in other countries. Yeah. So it's good to hear.
I hope it stays that way in the UK. Yeah.
Yeah, exactly. So there is another milestone on our journey, 1st of January 2024, as I believe. But do you want to add anything or to this period 21-24?
Yeah, maybe just for completeness, let me briefly address the other pillars of EU VAT law. So we had the implementing regulation. Technically, I do not know why. Technically, it was repealed in one provision, and then another one said, but it continues to be relevant for interpreting VAT law as long as the directive is relevant. So in essence, it stayed in force. So for things like fixed establishments, that kind of clarifications in the implementing regulation can still be used in UK VAT law. We even had the Phoenix case on Article 9A was of course the UK referral. So
okay, right.
That's applicable. That's applicable as well.
Okay, Phoenix case was actually it was referral. And it concerned background from this period, 21 after 21, right? Or
no, it was
no. Okay.
So the transactions took place before, and it was also referred before the end of 2020 because there can be no new referrals.
Okay. Referrals are no longer applied. Yeah, referrals. Yeah. Okay.
Exactly. There is a carve out in the Withdrawal Act. Actually, that the one thing that has not been taken over into the post-Brexit period is the ability to change the validity of EU law. So the argument that something in the implementing regulation was ultra-virus the EU competencies and therefore should be quashed. That's no longer available in UK law.
You need to repeat it so that our listeners understand, because you used so many technical terms.
Sure, no, that's fine. So if you take the Phoenix case as a practical example, you had Article 9A in the implementing regulation, which made the platforms in streaming for streaming services the deemed recipient and supplier of the live stream, so that they would owe VAT on it. And the argument there was that it actually was ultra-virus, so that it was illegal to create such a provision in the implementing regulation. The argument being it goes beyond implementing the VAT directive. It creates new law, which and that was then referred by the UK tribunal pre-Brexit to the CJEU, who actually found that no, it's all fine. It's just it's within the competencies of the institutions to do that in an implementing regulation. But if it had not been the case, then essentially Article 9A would have been invalid and would have not existed for EU VAT purposes. And what you can now no longer do in the UK is to say, probably an unlikely example, but let's say the article on fixed establishments, it says something you don't like. You cannot say in the UK now, oh, actually, I look back at the legislative history when they put that provision in the implementing regulation, there was some procedural defect or whatever, and actually it's void and it shall not be applied. That's not something that's available in UK law as well. And I think it's quite a pragmatic thing to have that carve out, because the UK courts can no longer refer to the CJEU, and it would be very strange if a UK tribunal had to decide on its own whether something in EU law is invalid or not. So that's probably a pragmatic carve out.
Yeah, but generally implementing regulation did apply.
Yes, it does. Yeah, you can still rely on it for example, what's a fixed establishment, when is a service land related, all those helpful things that are clarified therein. Next pieces, of course, very important one, the case law of the Court of Justice of the European Union. The case law, again, has been taken up until the 31st of December 2020. Up to this point, the case law continues to be binding. The Court of Appeal and the Supreme Court were given the power to depart from that case law if they consider it right to do so. But the legislation says that they need to apply the same test as they apply when departing from their own case law. And given that we are a common law jurisdiction, we have strong precedent. It's very difficult, actually, even for the Supreme Court to depart from its own case law.
So it's something specific. So something specific for UK law, because people from the continent, it might be misleading or to some extent confusing or something, because so everything applied, also the general principles of EU law, but the higher courts, let's say, could deviate from this more or less because, and more or less as they sometimes do in terms of their precedents that are binding in the UK. So this is the specificity. Okay, but generally and also in practice it is very difficult to deviate. So we can assume that generally the general principles of EU law applied.
Yes, no, absolutely. So the case law of the CJEU you can still rely on, and it's binding, especially on the lower courts.
Oh, sorry, we were talking about case law, right?
Case law, yes,
no, general principles. Yeah.
No, I'll get to them in a minute. They have some of their own peculiarities. But so the case law, in principle, you can still rely on. With regard to CJEU cases that have been released from the 1st of January 2021 and onwards, the legislation envisages that the courts may have regard to such case law. So that's the terms that are used. Courts and tribunals may have regard to post-Brexit European case law. In practice, especially if you have a later CJEU case that clarifies earlier case law that is binding, there's a very strong argument that courts and tribunals should have regard to such case law. They mostly do. I'm aware of, in the field of VAT, only one example where they didn't. The Court of Appeal. Court of Appeal had a case before it where there was a defective invoice missing a VAT ID. Missing the VAT ID of the supplier, and it transpired that the supplier actually, in fact, wasn't VAT registered and that they had disappeared under fraudulent circumstances. The taxpayer asserted that Chemwater Pro Chemie was authority for the proposition that actually the VAT invoice as a whole is only a formal requirement, and that because the substantive requirements were fulfilled and HMRC couldn't bring them within the Kittel carve-out for input tax deduction, they should be allowed to deduct input tax. And there the Court of Appeal considered Chemwater, a post-Brexit judgment, and said we think it wise not to have regard to it.
So they didn't have regard for this Court of Justice ruling. which was settled by the Court of Justice of the European Union post-Brexit. And so the UK courts still apply the case law, but in terms of formal obligations and formalities, they don't like that.
Yeah, they didn't like that specific one at
Okay.
least.
At
So
least
the
this specific one. Mm-hmm.
yeah, I think it cited Ferry Mid, which was a reverse charge case, actually Camwater, and they said, well, the Court of Justice, the CJU was a 3-judge panel without the opinion of an advocate general, simply transposed something that applies in the context of reverse charge to regular supply, and they said,
Okay.
well, we think that's, well, it's a step too far. That's not something that a 3-judge panel without advocate general opinion should do so lightly, and therefore we think.
So
it's the only one. It's the only one. It's been couple of years
do
now.
you want to add anything here on principles or something, because there is a long way ahead of us? So do you want to drop one more sentence on principles, or we are moving to the next milestone?
I think one sentence on principles would be interesting. So they also have been preserved by the Withdrawal Act, but there is a carve out that says there shall be no right of action in domestic law based on a failure to comply with EU law general principles. That's a carve out they've said. So there's no freestanding right of action based on general principles or on a failure to comply with principles. HMRC have taken that and have said the so-called Reemtsma claims are no longer available. So, Reemtsma, you have paid VAT to a supplier. It transpired the transaction should have actually been exempt, but you can no longer get back your VAT from the supplier because they are bankrupt.
So you
or whatever.
have direct claim to the tax authorities. Mm-hmm.
Exactly. And HMRC say, I disagree, but HMRC say, well, that's a course of action, a right of action that's based on a failure to comply with general principles of EU law, because based on neutrality and so on.
And now a short break and a quick tip, because we have prepared something special for you. It's a Court of Justice VAT rulings database. It contains all VAT judgments and orders issued since the 70s, with search, keywords and links. And not just that, the best thing is that the database will be updated periodically. And how to get it? By subscribing to our free VAT newsletter, link in the description. And don't forget to like and subscribe to this podcast for more VAT discussions like this one. Okay, so under EU law, you have this claim directly to the tax authorities if you are not able to get the VAT back from your contracting party. And HMRC claims that it is based on EU general principles of law, and that's why they say that it's not longer available in the UK, this claim directly to the tax authorities. Interesting.
Exactly. And the counter argument from my side would be it has been recognized by the UK domestic courts, actually, that it exists pre-Brexit.
Oh, okay. So this is interesting. See, this is interesting because there is this carve-out. So the Withdrawal Act, as I understand, says that to some extent principles, to simplify a little bit, the principles to some extent do not apply. And now we have HMRC who says that in this regard, this is the case that we cannot apply these rules. But the courts say that we still can apply this claim directly to the tax authorities.
So it hasn't been decided post-Brexit yet. It hasn't been decided. My argument would only be because you have pre-Brexit case law, domestic case law that's recognizing it. There is actually no failure to comply with general principles, and therefore that carve-out isn't applicable. But that's something, it's procedurally slightly difficult to bring those claims. I hope sooner or later a case will arise before the courts.
Okay, so we have spent quite a while, because already I see half an hour on the period between 2021 and 2024. So let's move to the most important thing. How does it look like now? Starting what happened on 1st January 2024, and how does this system look like today?
from the 1st of January 2024, so for transactions that occurred on or after that date, in principle, in other fields of law, the Withdrawal Act 2018 has been curtailed significantly by the retained EU Law Revocation and Reform Act. I'll just call it a Revocation Act for obvious reasons.
So on the 1st of January 2024, a new EU Law Act came into force, which is the let's call it Revocation Act, because it revokes the EU law, right? Can you put it that way, right?
Exactly. It revokes significant parts of EU law, at least. It's kind of a difficult question what exactly its impact is in other fields than VAT.
Okay.
So I will leave that to people.
Exactly. Let's focus on VAT.
Better place to comment on fields outside of VAT. For VAT, we are put in quite a special position in the UK legal order, so probably that also shows how important EU law is in the field of VAT. So for VAT law only and for excise duties, these are really the only fields. There have been significant carve-outs to that Revocation Act.
To simplify, the whole body of every law and so on was revocated. To simplify a little bit, because we are not discussing other fields of law, but generally everything was revocated. So EU law does not apply in the UK, but there are specific provisions specific for VAT and excise, because those fields of, let's say, trade or this field of economic activity of taxation is so important that there are specific provisions for VAT and excise.
Yes, exactly. So I think the HMRC or the Treasury was just conscious that they did not want any unforeseen consequences in the field of VAT, which of course is a very important revenue source to the state. So it was quite early. It was actually said when the first draft of the Revocation Act, the Revocation Bill, back then went through Parliament, that there will be a bespoke scheme for VAT and excise duties. It wasn't introduced until very late, so some part throughout the journey we already lost hope and were concerned that actually VAT will be affected as well by that revocation. That didn't happen actually. So VAT is put in a very special position in the sense that what is very clear is that for the purpose of interpreting VAT law, all the EU law that was of relevance before the 1st of January 2024 continues to be of relevance as well. So the supremacy of EU law, for instance, has been retained, again, for the purpose of interpreting VAT law. So if you have any domestic provision, you would still look at the directive, you would still look at the case law, again, that separation binding before 2020 from 2021, you may have regard to it, but in principle you'd still have regard to all of that for the purpose of interpreting domestic VAT law. That ensures that there is continuity in the most important fields, I think.
So starting from 1st of January 2024, so for example, as we speak today, if there is any taxable activity today in 2025, August or September 2025, if there is a taxable activity or any economic activity, we would apply UK law, UK VAT law, but for the purposes of interpretation of this law, we can take benefit, let's say, of the whole body of the European Union VAT law, but not as it is right now, but as it was in 2024?
Well, in principle, as it was on the 31st of December 2020, but with the addition that you may have regard to later case law from the CJU, which most of the time it's sensible to have regard to that later case law. And with the one exception I mentioned earlier, most of the time you can look at later case law as well.
Mm-hmm.
What is the interesting question there, and that's just not settled as of now, is what are the boundaries of interpreting domestic law? So what the bespoke scheme for VAT says is that you cannot quash or disapply domestic legislation based on EU law, based on something in the directive, based on general principles. General principles, you couldn't do that before as well, but
you need to have regard. You have to have regard, and you have to respect the domestic law of the United Kingdom. This is the first thing that is binding for you, right? Yeah.
Yes, I think that's fair to say. Bearing in mind that, of course, the principle, the leasing principle, conforming construction, you can go quite far to mold the domestic legislation if necessary to comply with the directive, for instance. The really interesting question is whether direct effect still applies, whether you can still rely on it.
And I understand that there are articles of yours that you have written that where you argue that direct effect also applies, and I don't know if it's possible. We will give our audience the links to these articles if it's possible. I don't know if it's possible. If it is, there will be the links. Tell us 2-3 sentences about this.
Sure. Yeah, I think the majority view, to be fair, and unsurprisingly also HMRC's view, is that it's no longer possible to apply direct effect. It's not so easy in my view because this legislation, the Section 28 of the Finance Act 2024, it did have a provision that said retained this wording of all rights, obligations, and so on from EU law as they were available in the domestic legal order continue to be available, and that shall still apply for the purpose of interpreting VAT law.
For the purpose of interpreting.
For the purpose of interpreting, and I appreciate you cannot quash or disapply anything, but the case for direct effect would be, well, on the one hand, if rights from direct effect aren't retained under that provision, then what is retained under that provision? If you just wanted to preserve conforming construction, well, another subsection in legislation already does that, and it could have been said in much simpler terms. So that's the argument to say, well, actually, if that provision is not to do nothing, if you're not saying Parliament did some nonsense here, then it must preserve direct effect. And the second hurdle you need to overcome is to say by applying direct effect, you're not quashing or disapplying domestic legislation. There is some helpful early authority that says, well, direct effect that doesn't mean setting aside any domestic law. It just means that the state is stopped from relying on domestic law. And it's a kind of a legalistic distinction. But estoppel just means HMRC isn't allowed to invoke it in proceeding against you. And that's something different, I would argue, than disapplying or quashing. But it's something that the courts...
Okay, so generally there is this this standpoint of yours that was expressed in those articles that you have written, and that generally, obviously, for the purposes of interpretation, the EU VAT law still applies in the UK for the purposes of interpretation, but the direct effect is debatable. But according to your standpoint, we could defend the position that it's still available, the direct effect. Okay, so this is interesting. Let's move on in the sense that, let's say a practitioner or academic or other professional if he or she wants to summarize it, to have it summarized in one sentence, generally for the purpose of interpreting the UK VAT law, we can use the EU VAT law still.
Yes, so I think for practitioner from the EU who would move to the UK today, for instance, or who is advising with transactions related to the UK, they would find that a lot is still very similar because precisely for the reason that we still interpret domestic law in accordance with the directive. The fields where it's not so easy are mostly those that aren't that harmonized by EU law in the first place. So what we did have recently, I don't know if it was in the news on the continent as well, but here in the UK it was a big topic that the VAT exemption on private schools has been removed, so that private schools in the future will be taxable. So that's one of the things that's a change in the law post-Brexit, and that's then, of course, no longer governed by any EU law principles. So you cannot say that it should still be exempt because of some provision in the directive or whatever. That's a choice of domestic law post-Brexit that Parliament is, of course, free to make, and that then applies based on domestic law alone. But otherwise, the general structure, most of the principles, most of the fields in VAT haven't been touched yet post-Brexit, and therefore you'd find that a lot the same.
This is interesting. So generally now the status is that if there is some kind of provision or on exemption on financial services or a right to deduct or any other provisions about supply of goods, supply of services, all those provisions, generally we can assume that we can interpret those provisions using the EU VAT law, body of EU VAT law, including the standard classic case law of the Court of Justice of the European Union. And what about if there is a new case decided by the Court of Justice of the European Union, for example? Let's move into examples. So, for example, there is this discussion about transfer pricing adjustments, and there is this case that was commented on in the opinion of the Advocate General. Now we are waiting, because we are in August, so we are awaiting for the judgment in this TP adjustment case. And will that have an effect, for example, for the UK VAT law system?
So it's that somewhat difficult to predict test that tribunals and courts may have regard to it.
Okay.
In principle, again, there's nothing groundbreaking, I think, in that case as such. It's just that general principle that you need to have a direct link between a supply and consideration pursuant to a legal relationship and so on, that you will have applied that by the CJU to a specific set of facts. Now, in those circumstances, the case for having regard to that CJU case is very strong, because you are bound by the earlier case, Tolsma and so on, that says you need to have a direct link. And then that case law is binding, that's binding on you, is clarified by the same court that released it. Of course, it makes sense to have regard to it.
And also, it is a strongly matter of interpretation, right? Because I am not an expert in UK VAT law, but I understand that there is a concept of supply of goods, supply of services, remuneration for those supplies, and so on, So all the basics elements are already in the VAT. In the UK VAT law, it's a matter of interpretation how to approach this for the backgrounds, for the transactions of TP adjustments, right? So but I got your point. I mean, these are the situations in which it is hard to predict. It is hard to answer for 100%. To be sure, for example, but there are strong arguments to claim that it should have effect, and the UK courts should follow what the Court of Justice says in this ruling, if it's clear, because obviously it might not be clear.
Absolutely. I mean, maybe to give one contrasting example that's very closely related, the other TP-related case that we have, where the judgment was recently released, the Swedish one, where the question was, are certain administrative and management services, do they form a single supply or not? The conclusion there reached by the CJU is, well, at least intention to that what UK courts have said in similar circumstances. So domestically, JP Morgan has currently a case going through the instances where the first two instances, the first tier tribunal and the upper tribunal, have actually said no for us. So they were released before the recent CJU judgment, but they said, we think if you outsource all those management and administrative services and so on, the point of that outsourcing is that you get it all out of one hand, and that actually forms a new single supply of a unique nature, one of its kind, and therefore we're treating it as a single supply. So that's more or less the opposite of what the CJU has decided in the Swedish case. It is, of course, possible, so that will go before the Court of Appeal now, that the Court of Appeal there will say, and there's some older case law from the House of Lords as well going in the same direction, that they say, no, actually, we prefer our domestic test. We think it's more sensible than what the CJU has said, and we will not have regard to it. So
we never know. I mean, to some extent, if you are a solicitor or a lawyer before a court, you can try to convince the court that the interpretation that is applied in the EU VAT law is the right way to go, but they may decide otherwise. Also, it's difficult to predict.
Exactly. I mean, what's always helpful, if you can, is to find a domestic case actually saying the same thing.
Okay,
that's then binding. So I discovered recently, if you take the CJU, the LevOp case, so that's the single supply was the predominant element that expanded the CPP case law. I discovered that the House of Lords, so that was back in the day, the Supreme Court, 1 week before LevOp was released its decision in a domestic case, and the test they applied is actually very, very similar to LevOp. So there's, I think, strategically a question: can you find a domestic case that's actually saying the same thing, and then you're not subject to that uncertainty.
It seems that a lot of work for lawyers, because the system gets complicated. I mean, to some extent, we can base our interpretation of EU law. To some extent, maybe we should look for the past case that is similar, and so on, so on. So a lot of work for lawyers. Okay, so let's go case by case or example by example. If you could, address my question in a short manner. For example, so having said all the things that we have said, starting from 2024, so as we speak, for example, the formal obligations, when we have this concept in the EU law that if the substance conditions are met, you can omit, to simplify a little bit, but you can omit the formal obligation. So to our listeners, for example, if I have, export transaction, the question is whether I need to have very specifically enumerated documents in the VAT law to prove the exemption of exports, or I can base on whatever proof I have, or even without proofs. To some extent, the tax authorities are obliged to look for this proof. So would that concept of formal obligation apply still in the UK law now, as of today?
In principle, yes, because that case law is binding. In practice, it's not that big of an issue in UK law, because HMRC always have the power to consider alternative evidence and to take that into account. And if you have really strong evidence that the goods have been exported, then it would be an unreasonable exercise for HMRC's discretion to say, okay, we've seen all that evidence, but because it's not in compliance with the strict list, we won't take it into account. That just from a public law perspective in the UK would already be illegal. So that case law on substantive and formal requirements never had, I think, quite the same impact in the UK than in more formalistic nations, perhaps.
Yeah. Okay. So, interesting remarks on formal obligations. What about the composite supplies, for example? There is a whole body of case law of the Court of Justice of the European Union on whether a supply is whether we are dealing with one composite supply or whether the transactions that are grouped under the one big transactions should be considered separately. Would the European Court of Justice case law apply in this regard also in the UK?
I think that's a pretty strong yes. Most of that case law has also been summarized in a number of domestic cases. So by virtue of that, so we had in the Court of Appeal a case called Crane Farrar, which summarized a lot of the EU principles. We had Middle Temple in the Upper Tribunal. So all of that is available in domestic law anyways. Where it's less clear is if it now evolves at a European level in a direction that we currently cannot foresee. So there were recently some cases also requiring, I don't remember its name, but a very recent one saying we require a mutual dependence between the different elements for there to be a single supply. If something happens there at a European level in terms of evolution that is currently not part of the European case law, then I think courts would be more cautious and would consider very carefully whether we want to domesticate that in the UK or not.
In terms, for example, when you're assessing whether services are related to real property, it is regulated in implementing regulation. How would that, would you apply those criteria that are enumerated in the implementing regulation?
Short answer, yes.
Answer is okay.
The implementing regulation, explicitly remains of relevance.
Remains in force, right? This is something that we haven't underlined yet, but it remains. Implementing regulation remains in force.
And was again the carve out, just very briefly. If it said something that was in conflict with domestic law, then probably not. I haven't come across any such example. But
okay.
As long as domestic law is silent, like in the example you've just given, by all means look at the implementing regulations, and that will govern the situation.
Okay. Let's say general principle of effectiveness. There are many different cases in the Court of Justice of the European Union case law that refers in field of VAT to the principle of effectiveness. For example, that the proofs that you are obliged to render during procedures, it cannot be difficult or not possible for you to render those, or excessively difficult or impossible for you to render those evidence. This evidence, could that also be invoked in the UK as of today?
You could still invoke it for the purpose of interpretation. You could probably not invoke it to quash domestic law. So you could not say that provision is against the principle of effectiveness and we are going to ignore it completely. But given that you have in general in UK public law certain obligations on the authority to act reasonably and so on, principle of effectiveness perhaps in the UK doesn't have quite the impact that it has maybe in other jurisdictions.
Okay, great. So this is we have gone through the quite a picture of the EU VAT law EU VAT law in the UK as it stands today. For me, the general impression is that if it is a common sense to apply, if there are strong precedents, or it is or they are compliant with a common sense, it is a fair chance that those rules will prevail still in the UK VAT system if it's something very, very specific and maybe strange, maybe aggressive, or maybe something that has no grounds in the UK law, that the chances are lower. But it is something to be discussed before the court, and at the end of the day, to summarize, there are strong arguments to try to invoke EU VAT law, but still, whether it will be applied in practice or not, it is up to the courts.
Yes, I mean, the lower the instance you are dealing with, the stronger they are bound. The higher up you go through the court system, the more confidence they probably also have to depart or not to have regard.
Okay. So thank you for that. Thank you for the general picture of this VAT law, of the EU VAT law in the UK. If you don't mind, I wanted to ask you also about something. Let's say some other aspect of the practitioner who deals with the EU law and UK law. After Brexit, what are the positive and what are the negative, what are the disadvantages and advantages of the fact that the Brexit happened for the VAT law? Of course, we are talking about VAT law, and of course, setting aside all the political discussion, but there must be some, let's say, more professional, more technical aspects on which you can comment in terms of whether there are any advantages and disadvantages of Brexit when it comes to VAT.
I mean, as a lawyer, first of all, it has all been very interesting. It has led to interesting legal questions. I guess what we will see in the medium term is whether it leads to more certainty. Surely, in the short term, it has rather led to uncertainty, because there's a question. There are all those questions that we have discussed. When is it right to have regard to EU law and so on? In the medium term, I could imagine that the UK courts maybe are a bit more consistent and erratic than the CJU can sometimes be in terms of further developing the VAT law and continuing the evolution of VAT law, simply because you have one Supreme Court, just a small number of 11 judges, and then the Court of Appeal as well, and so on. So you don't have the constant change that has, I think, been a bit of a feature of CJU case law, where you sometimes have somewhat erratic changes. On the other hand, the downside is, of course, that we will have less case law overall. It's clear a country the size of the UK will produce less case law than 450 million people in the EU will produce. That's just natural.
Okay, so this is very, very interesting, and this was actually initially my intuition, that you say that there is a chance that the VAT case law will be more coherent.
I would expect so, simply because the way the common law works and the system of precedent works is that courts are quite strongly bound by what has been said before and should only move on from there and only evolve the law very carefully. And in addition, what you do have, I don't know if you've ever read British or other common law judgments, but they tend to be significantly longer, and the reasoning, the thought process of the judge tends to be elaborated on in much more detail than is the case in CJU
exactly. This is my also impression, that I would fear that, I mean, my impression is that the Court of Justice of the European Union formulates its judgments in a way that sometimes you don't exactly know why the conclusion is as it is, right? Sometimes there are no or very little grounds for why the conclusion as it is. But you say that in a British system, this is elaborated more clearly.
Yes. Usually it is. So usually judgments run over 20 pages or more. They consider all the precedent, and then not always. Of course, there are examples of bad judgments as well, like everywhere. But it's usually easier to follow the thought process of the judge. Also, because different than in the European Court, there's no consensual writing as such. So it's even in the higher courts, even in the Supreme Court, where you have a 5-judge panel, it's usually one judge writing the lead judgment, and then the others may agree, or they may write a concurring opinion, or they might dissent. But of course, naturally, if something is written by one person, it tends to be more coherent than, if 3 or 5 persons need to agree on the same text.
So it seems that it can the Brexit in that very strict, let's say, sense that we are talking about may turn out to be something positive for VAT system in the UK, because as I understand, all those principles more or less are applied or are resembled somehow in the UK system. And at the same time, the court's judgments could be more clearly put. So maybe it is a positive thing for Britain.
I might be speaking with the bias of a common lawyer. Of course. I prefer common law judgments. Maybe some civil lawyers.
I see. That was my impression. I haven't read many of those, but a couple of British courts judgments on VAT, and I always had the impression that actually an envy that they are elaborated clearly. I know what the thought process is, and I may agree, might not agree, but I know at least what was the thought process leading to the conclusion, right? And this is completely not the case with the Court of Justice of the European Union. It is not the case many times with the Polish courts, for example, and so on, so on. So this is something good in Britain, yeah. Thank you for discussion. I would like to do a little summary. So if we were to summarize in one sentence the effectiveness of the EU VAT law in the UK, I understand that although UK left the EU, there is significant amount of space to look into the EU VAT law to interpret the UK law. So if, for example, I don't know, VAT director of a group that sits in France and doesn't have time or anything to dive very deeply into the details of the UK law, he or she may assume that the general logic elaborated in the case law of the Court of Justice or generally in the EU VAT law has significance in UK.
Absolutely. Yeah, that's a fair summary. A lot of it continues to apply. A lot will be still familiar. How much it ultimately diverts over time depends, on the one hand, how eager the government, parliament is to legislate in the field of VAT. So the major reform we've seen are the private schools, but otherwise I didn't see much enthusiasm on the side of parliament so far to be very interventionist in the field of VAT, and then ultimately what the higher courts do if they want to move on from European case law. But in the meanwhile, a lot will be very familiar. Definitely.
Okay, thank you very much. This is a good summary. Thank you. Once more for being here, for explaining to us all these things, and thank you once more, and take care.
You too.
Thank you. Goodbye.
Goodbye.
Welcome to the Vatvocate podcast, where we explore all things value-added tax to give you the insights you need as a VAT professional.